Did you know that some students find it tricky to spot professional conduct and ethical issues in MCQs in SQE1? Well, in this episode, we're going to be unpacking some typical scenarios so you can spot them when the time comes in the next episode of SQE TV.
If you want to be solicitors, why don't you come and visit us at SQE TV?
In our first video relating to ethical and professional conduct issues, we took a look at the SRA Principles and also parts of the code and saw how you can map individual parts of the code to at least one of the principles. And then we showed you a scenario as to how those particular parts of the code and the principles might be tested in the SQE. What we're going to do in this video is to follow up more of the same. We started off with Principle 1 in the first video, so let's now move on and have a look at Principle 2.
SQE TV.
So let's have a look at what Principle 2 says. It says you act in a way that upholds public trust and confidence in the solicitor's profession and in legal services provided by authorised persons. And what we said in our first video is that the code of conduct for solicitors and code of conduct for firms, you can always map individual parts of the codes to at least one and probably several of the principles, the SRA principles. So let's have a look at the code of conduct for solicitors 3.2, which reads, you ensure that the service you provide to clients is competent and delivered in a timely way. And what we're saying is you can map that to at least one principle, and we've shown Principle 2 here. And if you think about it, it's really important that the work you do is competent and done on time in accordance with your client's realistic expectations. And if that doesn't happen, then you're not really going to be upholding trust in the profession from your clients or generally in legal services that are offered by authorised persons like law firms. So let's have a look at how we might be required to apply this in the context of a scenario either in an SQE1 or SQE2 exam. So our scenario is you act for the executor of an estate who wished to sell a piece of artwork which forms part of the estate. The executor was approached today by a prospective buyer with an offer which is only open for acceptance for the next 7 days. You do not expect to receive the probate valuation for another fortnight. You are a keen art collector and are of the view that the offer is a fair one. So what's the ethical dilemma here? Well, the ethical dilemma is actually you sort of know a little bit about art. So the question is, well, are you in an appropriate position? Are you the appropriate person to be able to sign off on the fact that this is a fair price? And I would question whether you are in this situation simply because just because you're a collector or a fan or have some knowledge of a subject, it does not necessarily mean you are the best person or the right person in this case to give a valuation. So I would very much encourage you not to accept the offer without trying to accelerate the probate valuation or maybe going to a third party to get it valued quicker than the 2 weeks that you're waiting for. That way and only that way will you be in a position to be said to uphold public trust and confidence in the profession by taking the advice of an expert rather than just going on what you think might be right based on your interest in the subject matter.
SQE TV.
Now, what we've started to do in this video is to give you a structure once you've spotted that there's an ethical issue as to how you should approach it and come to the right conclusion in the end. And the first thing is obviously to spot the ethical or professional conduct issue, and then just to make it clear in your head, ask yourself, why is it an issue to my client? And then think about the relevant parts of the code or the principles and then apply them to the facts in order to reach a conclusion and a solution. So let's now go through that process for Principle 3, which says you act with independence. Very short principle. And let's map to that one part of the Code of Conduct for Solicitors, which is 6.2, which says you do not act in relation to a matter if you have a conflict of interest. We've slightly abbreviated that just for the sake of teaching purposes, but that's the essence of CCS 6.2. You'll see there's a footnote here to CCS 6.2 which reminds you that there are exceptions to the general rule that you can't act in the case of a conflict of interest. And just a tip as an aside here, make sure you're really familiar with what those exceptions are. We're not going to cover them in this video, but as is the case with a lot of the multiple choice questions in SQE1, not only are you being tested on the rule, but you're being tested on the exceptions to the rule. So make sure you're really familiar with CCS 6.2a and CCS 6.2b, which cover the exceptions, which we'll deal with in a later video, I'm sure, in the future. But let's now have a look at an exam scenario where you might have to apply both Principle 3 and CCS 6.2. It's quite obvious why they go together, because you can't be acting independently if you're acting for more than one client where there's a conflict of interest. So here's the example scenario. You act for the seller of a business, and one of your existing clients wishes to buy the first client's business. So acting for a buyer and a seller in the context of a property transaction, a business transaction, or anything else, or when you're opposite sides of a piece of litigation, clearly there is a conflict of interest. So yes, we'll need to work out whether or not any of the exceptions apply, but the general rule is that you shouldn't be acting for both parties. So why is it a problem? Well, obviously, if you think about it, if you're negotiating a deal, whether it's on price or having to draft contracts and other documents like security documents sometimes, if it's a property deal, or warranties if it's a sale of a business, then you're going to be heavily negotiating those. And if you're acting for both parties, how on earth can you negotiate with yourself? Exactly. So the general rule that you shouldn't act in cases of conflict of interest normally prevails. But make sure that you are there to apply the exceptions under 6.2a and b, as we've mentioned earlier.
SQE TV.
In our first video in this series on ethics and professional conduct, we mentioned that there was a test you can apply that can sometimes flush out a professional conduct issue that might be buried within a scenario. And the test was what we called the smell test.